Good afternoon, everyone. My name is Lluc Cerda. I'm the managing partner of Samfiru Tumarkin's Calgary office. I'm the employment practice lead for Western Canada. Thank you for joining us today for another session of our question and answers on employment law. So we are here for the next half hour to answer as many of your questions that you have related to employment law. Feel free to put in any question you have into the chat. We're going to get to as many of them as we can today. As we wait for the first few questions to roll in, I also wanted to talk to some of you about an issue that's near and dear to us here at Samfiru Tumarkin, which is workplace safety, especially in connection with the heat wave that we've been having in Eastern Canada. We have some people reaching out asking, what can I do if I'm working outside in this extreme heat that we've been having? What are my rights? And it's very important to know that you do have rights when you're working outside or even inside, if you're working somewhere that's not air conditioned, if it gets too hot. All right. So under occupational health and safety legislation throughout, Canada, and especially in the provinces where we operate, which is Ontario, BC, and Alberta, where I'm located, employers have an obligation to do everything that's reasonably possible to ensure that the workplace is safe. All right. And what that means when we're getting to periods of extreme heat, as we do in the summer, and the same applies for periods of extreme cold in the winter. If you're outside, if you're working in the sun, and it's gotten very hot, we're looking at, temperatures over 32 degrees, humidex over 35 degrees, these kinds of things. Your employer should be making some accommodations so that you don't suffer from a heat stroke or heat stress. That can happen through, fainting, dehydration, vomiting, all of that, right? Serious stuff. So you want to make sure that you get home safe at night from your workday. You don't have to kill yourself on the job just to earn a salary. So some ways that employers can do that is giving you more time on breaks. For sure, there should be plenty of water available on the work site, shaded areas where you can rest. And sometimes just, if it's intense work, to try to keep it for the end of the day or the very beginning of the day, more strenuous work, so that you're not working as hard as you can under the beating sun of the early afternoon. If your employer is doing nothing and you are starting to feel that it's gotten too hot for you to do the kind of work that you're being asked to do, you have rights under occupational health and safety. A lot of you might know that you have the right to refuse unsafe work whenever that situation presents itself, but it can also present itself when it's too hot or in the wintertime when it's too cold. So the first step is to go to your supervisor and say, I don't think I can do this job that you're asking me to do. I think the work is unsafe. Your employer then has an obligation to investigate that and determine for themselves whether the work is safe or not. And then they'll come to a determination. Supposing they say, no, this is not unsafe work, go ahead and do what you're told, and you still feel it's unsafe, then you have the right to escalate the concern to the Ministry of Labor. So you pick up the phone, you call the health and safety officers at the Ministry of Labor, you tell them, listen, I want to put an unsafe workplace concern in because I'm being asked to do work and I don't think it's safe. The Ministry of Labor will go to the work site, determine if the work is safe or not. All right, and like that, you'll know that you have done everything you can to ensure that you're working in a safe environment. Important thing to know, you might say, well, yeah, but if I do that, I'll get fired. No, you can't. All right, they cannot. An employer cannot terminate you, fire you, discipline you in any way for enforcing your rights under occupational health and safety. So if ever you raise an occupational health and safety concern and you receive any type of discipline, cut hours, termination, you lose your bonus, whatever it is, call us. The best way to reach us is to visit our website at employmentlawyer.ca. You have the website on the screen there, and get in touch with one of us. We'll be happy to help. We want all of you to go home safe at night. to your family. So it's very important that you take your safety very seriously, as we all do here. All right, while I was giving you that explanation, we have some questions come in, so let's get to those. First question we have from Peter Ibbotson. Peter asks, can a group of employees do a class action on an employer? And if so, how many people would you need? How would the process be? So we get that question a lot, Peter, about class actions. Sometimes it's appropriate. Oftentimes we find that class actions are not appropriate. So if you want to maybe continue in the chat to explain to me what the issue is, I can explain to you a little bit better whether I think it's advisable. The main problem with class actions is how long and how complicated they are. And especially if it's a small class, which seems to be the case here, it might make sense to just do individual actions. You can then join those actions so they all happen in one trial. But proceeding by a class action is quite a level of complication. It's unlikely that it be resolved within less than 5 years in our experience. So it kind of depends on what the issue is. Peter's Peter's jumped in with a bit more information. Peter is asking, if a job makes you do a drug and alcohol test, even if it's not in a contract, you pass the alcohol, but use marijuana personally, and that came positive. My job is now withholding me from working. So that situation, Peter, I don't think would be great for a class action. So essentially, what you want in a class action is a certain level of commonality between all the employees, all right? So we see class actions, for instance, where people are denied overtime pay. People are classified as independent contractors when they're really employees, and they all kind of do the same job, right? And so there's a lot of commonality there. And if you find that one person is not an independent contractor but rather an employee, it's easy to then take that finding and apply it to the rest of the class, because they're all basically in the same role. When you're dealing with drugs and alcohol, there's a lot of different issues. Yes, the policy is the same for everyone, but each individual who's had issues with drugs and alcohol is different. Were they tested after an accident, or were they tested as you were in relation to an alcohol, a need to test for alcohol, and then marijuana was found? Were they found to have violated an alcohol policy, a drug policy, a marijuana policy? All these things are different, and then each and every one of them might have an addiction to this alcohol, drugs, or drugs, which then triggers human rights obligations. So each individual is so unique that I don't think it would be appropriate to proceed as a class action. That said, it may be, if there's a small number of you, that you can each proceed individually to challenge the drug and alcohol policy. Some of you may have been terminated. You seem to be on some sort of suspension. Again, that kind of creates differences in the class. Some might have been asked to undergo treatment. Others may have been just terminated outright. So there's too many differences, I would say, Peter, for this to be an appropriate class action. But like I said, if there's 15 of you, why not start 15 lawsuits, right? It's not a problem, really. There's no issue there. So if that's something you want to discuss with us in more detail, maybe get a bit more specifics about your situation, reach out to us at employmentlawyer.ca. We'll be happy to speak to you, get a bit more background on what's happened at your workplace, and see how we can help. So definitely feel free to reach out. All right, next question comes in from Tony DeSico. Hope I got that right, Tony. Tony asks, how many days in Alberta do you get for bereavement leave? That's a good question, Tony. I don't have that on the tip of my fingers. I think it is 3 days, but I'd have to check. These kinds of leaves are well explained on the internet. If you type in bereavement leave, employment standards Alberta, you should be able to get that answer. I deal with employment standards legislation in three provinces, and I sometimes get them mixed up. I think it's 3 days in Ontario, but I can't say for sure on in Alberta. What I can tell you, Tony, if you're planning on tuning in on our next show, which is this Wednesday, Mr. Lyor Samfiru himself will be conducting Q&A. I will make sure to look at this answer right after we get off the air and let Lyor know that you'll be attending on Wednesday so that he can provide you that answer. I'd rather not give you the wrong information. And I just probably would need 2 minutes to check, but we're in the middle of a show, so I don't want to do that now. We got another question coming in from Bronto. Bronto asks, hello, can an employer enforce a non-compete in Alberta? The contract I signed is around 7 years old. Bronto, it depends. Mainly what it depends on is whether you were terminated or whether you quit. So if you sign a non-competition agreement, a few things to know. So you have to get something of value for having agreed to not compete with your employer, okay? So that means if you start a job and you sign an employment contract prior to starting your job and the employment contract has a non-compete, then what you've got of value in exchange for the non-compete is the job. If at any time after you started working, that's when they ask you to sign a non-compete, then you have to get something new of value for you signing that non-compete agreement. All right. So it could be a signing bonus, it could be a raise, it could be a promotion, more vacation, whatever it is. But there has to be something. So you only know whether you got something of value for agreeing to this non-compete. That's number one. Number two, in Alberta, the law is right now that yes, non-competes are theoretically enforceable, but only if it's not the employer it's not you, only if you resign, essentially, then it's enforceable. If the employer terminates you and doesn't provide you with working notice of termination, if they, for instance, pay you a severance package instead of giving you notice, then the non-compete is not enforceable. Okay, but if you're resigning, then the non-compete is enforceable. So I don't know exactly what your situation is, Bronto. Maybe you want to put that in the chat and I can kind of elaborate a little bit more on that. We have Stav Rob 1 asking, if someone is terminated after 5 years of employment, not unionized, what are they entitled to? This is in Ontario. Great question. So you have two areas of entitlement, Stav Rob 1. You have some entitlements under the Employment Standards Act 2000, the Employment Standards legislation of Ontario. And then you have your entitlements to your full severance. So your full severance, we have made this as easy as possible for you to figure out what you're owed. And we've put up a website. We just ask you to answer 4 questions. This is anonymous. You know, we don't take down your information unless you want us to contact you for a consultation. But you can go there, look at those 4 questions, and we will tell you what we think you're entitled to in terms of severance pay. And you have the website up there on the screen. It's pocketemploymentlawyer.ca. This should take you 30 seconds, pocketemploymentlawyer.ca, and you'll get what we think you might be entitled to. All right. Under the Employment Standards Act, you are entitled to certain minimum termination entitlements. And I want to emphasize that they're minimums. All right. You have the right to generally go after your full severance unless there is an enforceable termination clause in your contract. It's very hard to write an enforceable termination clause. We have had a lot of success in invalidating termination clauses that try to limit how much severance you're owed. So even if you look back and you find your employment contract from 5 years ago and there is a termination clause, I just want you to realize all hope is not lost. Have us review that termination clause. We'll let you know if it's enforceable or not. Supposing it's enforceable, then all you'd be entitled to is what might be under the Employment Standards Act. Under the Employment Standards Act, you're basically entitled to 1 week of pay for every year you worked up to a maximum of 8 weeks, okay? So if you've been there, let's say it's 5 years, you'd be entitled to 5 weeks of termination pay. On top of that, if you've been working somewhere for 5 years and your employer is big enough in the sense that they have a payroll of 2.5 million or more, which is probably nowadays about a large portion of employers. If you have, anywhere but more than 30 colleagues, then probably that threshold is passed. So then, if you are entitled, if you are of that size, then you are owed, on top of your termination pay, you're owed 1 week per year of what the Employment Standards Act calls severance pay. And that's up to a maximum of 26 weeks. So supposing that you've been somewhere 5 years and a day, you'd be owed 5 weeks of termination pay, 5 weeks of employment standards severance pay. Now, everyone gets confused because the employment standards uses severance, and we use severance to mean something more along the lines of a month per year of service. That's your full common law severance, all right? So that's the colloquial term for pay in lieu of notice of termination. That's what everyone calls their severance, all right? It's complicated, linguistic stuff, but all I want to emphasize is that your full severance is different than what the Employment Standards Act calls severance pay, all right? So when you go to our website, pocketemploymentlawyer.ca, and we tell you you're entitled to a certain amount of months of severance, that we're talking about your full severance, not necessarily what you would get under the Employment Standards Code. I hope that's clear. It can be complicated, but that's the way the law is written. Unfortunately, I had nothing to do with that. All right, we have our next question. Oh, Peter's followed up. Okay. Peter asked, appreciate the help. So you're saying that going individually rather than as a group would be better. Peter was the one asking about a class action. So yes, Peter, it would be better. Firstly, I think the issue that you have, which is, this policy, this drug and alcohol policy, as it relates to all of you, each of you is probably so different that proceeding as a class wouldn't work. You can all do individual lawsuits. And then once that's done, once you've started your individual lawsuits, if that's what it comes to, then it's possible to have some level of coordination between all of you, right? So that, the court isn't making 15 different decisions that can go either way. Instead, your actions can be joined together so that they proceed at the same time or one after the other, for instance. And that allows you to proceed kind of independently for the majority of the pre-trial steps, and then just have the trial together. Whereas class actions, you choose one person to represent the whole class. That gets challenged. The employer says, well, that person's not appropriate. No one's appropriate. Then we have to do a court date to even decide whether this can proceed as a class action. That takes ages. When that's done, nothing has been resolved. All we've determined is that, yes, this is an appropriate class action. And then it's, do you win or lose here, right? So all that can be parked. You can go ahead and sue individually. And then there are a lot of options to make sure that there's no inconsistent results, that the finding in one case will apply to the others without needing to use the class action process. I want to emphasize, a lot of people ask us, why don't we do a class action here? Class actions are not, I would say when the government decided to create class actions, they weren't thinking of employment matters all that much. They were more thinking, you've all bought a electric toothbrush. All of your electric toothbrushes are defective. You're suing the electric toothbrush manufacturer for the $30 you lost on the electric toothbrush. Makes no sense, but there are 100,000 of you, so $30 times 100,000 starts making sense, right? But employment is very complicated. Each of you have different severance entitlements. Each of you have different reasons for having been put through this drug and alcohol policy. All this stuff, this makes it very hard to proceed as a class action. We do class actions here. We're doing a class action against Uber. And again, it's to do with, are the Uber drivers entitled to minimum wage, to overtime pay, and things like that. It's not, the Uber drug and alcohol policy, or how much severance you're owed if you're terminated from Uber, right? That would be a bit too complicated for a class action. So a lot of people see class action, they think it's kind of a cool method of proceeding through court. You got to make sure it's appropriate. So I don't really recommend it in most employment cases. Yeah. All right. We have another question from Joe B. Joe B is asking, do employers have to pay for training time? If so, are they allowed to provide a lower than minimum wage amount for training hours? So any work that the employer requires you to do has to be paid. All right, Joe B. So yes, training time has to be paid. And there is no way that they can force you to take less than a minimum wage. Okay. Training time has to be paid, and it has to be paid at least the minimum wage. And so if your employer forced you to do training and decided to pay you less than minimum wage, and the first thing you do, you pick up the phone and call the Ministry of Labor, you call the Employment Standards branch, and you say, listen, I was required to work and they didn't pay me minimum wage. And the Ministry of Labor is going to be all over that. They're going to call up the employer and be like, what's going on here? Minimum wage, there's minimum in the word. You can't pay less than minimum wage. All right. So that's the start and the end of it. So if they're paying you less than minimum wage, not allowed, call up the Ministry of Labor. They'll look into that for you. All right. We have a question coming in from Facebook from Letitia. Letitia asks, the company I work for announced an office relocation earlier this year. A number of my colleagues have made accommodations to deal with the change in location. Some have purchased cars, others have moved or are in the process of moving. The company just notified us that they are canceling the relocation. What rights do we have in this situation? Well, that's an interesting one. Wow. Okay. So I would say that you and your colleagues' friends would have a claim under something that we don't use a lot in employment law, but is used more generally in contract law, which is negligent misrepresentation. Okay, negligent misrepresentation. What it means is that the employer, in this case, said something that you relied on to your detriment, and that something that they said, they made it in a negligent fashion. All right, so they should have known when they made the statement that they were relocating, or should have known earlier than when they actually told you that what they said about relocating was untrue, and they didn't take steps to correct that. And therefore, you relied on their statement that you'd be relocating. You sold your house, you bought a new house. You now are going to live too far potentially from work to go there, so you might have to quit. And you've incurred all these costs to move or to buy a car and stuff like that. And so your claim is for these expenses that you would not have incurred had they not made this negligent misrepresentation. So that would be your rights, essentially, is to sue your employer for negligent misrepresentation. Not a great situation to be in. We saw the flip side of this a lot of times during the pandemic when people were told they could work from home. They sold their home and moved to the country, and then the employer's like, no, everyone's back in the office, and now that person's 3 hours away from the office or something like that, right? So I always tell people in that situation, when a change like this is happening, make sure to get it in writing. All right. It doesn't have to be a whole new contract, but if they tell you can work from home, make sure to get them to acknowledge that you can now work from home permanently. Right. So there's no surprises down the line when they change their mind. You can say, no, here's the email where you said I could do this. And so you cannot force me back into the office. I've since sold my house and moved to the country. I can't just go back to the office 5 days a week. All right, next question. Rob1 is following up here. Continued. So if an employer is offering 16 weeks combined, is that worth fighting to get to 20 weeks common law, or is 25 weeks with ESA possible? So Rob, I don't know much about you. I would think that while we were discussing your matter, you jumped on the website, I hope, and saw what we estimated you might be entitled to in terms of severance. And it seems that what you're indicating is what the website told you is you're owed somewhere between 20 and 25 weeks. You're asking me if it's worth fighting for. It's 25 weeks would probably be quite a bit more money. You'd be owed probably under the scenario 10 weeks plus an extra, maybe they're offering you an extra 16 weeks to get you to sign the documents. What I can tell you is it's worth speaking to us, because whether you sign their documents or not, that you are getting those 10 weeks. All right. So really what's in play is that extra 6 weeks that they're offering you to get to sign those documents. So it's up to you to decide whether you want to, fight for more. In my experience, a lot of employers, when they make you a severance offer in your termination letter, my experience is that's an opening offer. All right. That's not a line in the sand. We're giving you our best and final offer right from the start. That's not been my experience. So it's always worthwhile to check with us, see if we can help you improve that severance offer that was made. And like I said, I want to emphasize those minimums that you're entitled under the employment standards legislation, you get that whether you sign their documents or not. All right. So they won't pay you the full 16 weeks necessarily unless that's the minimum you're owed under the Employment Standards Act. But they will pay you what you are entitled to under the Employment Standards Act. They have to pay that to you unconditionally. It means you don't have to sign anything. You get that one way or the other. All right. So you won't be left with $0 if you turn them down, speak to us, and negotiate a better severance package. So that's what I can tell you about the process. Stavrob continues. Thank you. Well, thanks for tuning in, Stavrob. I hope the Pocket Employment Lawyer was helpful to you. For those of you just joining, Stavrob1 was asking, some questions about his severance entitlements. And if any of you are wondering, well, sure, we're talking about severance, but what is that? How much would I potentially be owed? I was just directing Stavrob to this nifty website that we've created. You answer 4 quick questions, and we will estimate how much severance you might be entitled to. So if you're wondering, well, how much are we talking about? What is this severance? There's a lot of misconceptions out there. That's why we have this show, because we want to dispel those misconceptions. So jump on the website, take a look. It's no obligation. You don't have to, retain us or anything like that. Just get an idea how much money we're talking about. Severance can be up to 2 years of salary, of your full compensation, including bonuses, car allowance, all of that. So it can be a very large amount of money. And some people don't realize that. They think, what is it, 1 week per year? Is it 2 weeks per year? It can be a lot more than that. So jump on the website if you haven't done that yet and get an idea of what you might be entitled to. Peter is also following up. Thanks for your insights. My pleasure, Peter. And if you are struggling and you do decide you want to take this a little bit further, reach out to us. The website was on the screen a little bit earlier. To get in touch with us, employmentlawyer.ca. Employmentlawyer.ca is how you reach out to us. All right, I got 2 more questions and we're wrapping up. So I'll answer these 2 more questions. If any of you are holding back on questions, know that our next show is this Wednesday. It's 1 p.m. Eastern with 1 p.m. Eastern with Lluc Cerda himself. He'll be answering questions from you live. So anything you weren't able to answer today, tune in at 1 p.m. Eastern on Wednesday and we'll get those questions answered for you. All right, 2 last questions here. I have one from Shauna Armstrong, her. Shauna is asking, hello, I'm currently off on WSIB I'm not sure that will affect my situation, but prior to me going off, I believe my employer engaged in constructive dismissal tactics. What are my options? Well, your options might be, I don't know much about what your employer did to make you think that you've been constructively dismissed. But if you have been constructively dismissed, then you have the right to sue for constructive dismissal. It doesn't impact your ability to collect WSIB payments. And basically you'll be able to pursue your severance through litigation or even pre-litigation negotiations if your employer has demonstrated they don't want to employ you anymore through their actions or inactions or what have you. That's really what we're trying to determine. Would a reasonable person find that your employer really, by their conduct, doesn't want to employ you anymore? All right, and that can manifest itself in different ways. It could be a demotion, it could be a pay cut in hours. It could be other things, though. It could be toxic work environment, bullying, a series of smaller things which on their own don't amount to constructive dismissal, but when taken together makes you realize, yeah, this employer doesn't want to employ Shauna anymore. And it's obvious, but they won't put their pants on and actually terminate you. So that's when constructive dismissal comes in. So being on WSIB does not prevent you from bringing a constructive dismissal claim. It's very important to remember, Shauna, however, that you only have a certain amount of time to sue. So it's not that you can sit on this for 2 years. Usually 2 years is the time you have to sue in court generally. So keep that in mind, all right? You might be wondering, you might not be sure whether you want to do this or not. May as well talk to us, all right? Reach out to us at employmentlawyer.ca. Reach out to us. We'll at least tell you what your options are, whether you have a strong case or not, and how you can go forward in pursuing your constructive dismissal matter. All right, we have another question from Joe B. Joe B says, thank you. My employer has yet to ask for my SIN as well. I'm worried that I'm not employed legally. Would I be in trouble for this? Yes, this is starting to get a little bit fishy, Joe B. This is getting quite fishy, frankly. If they don't have your SIN, then they can't deduct taxes. And so I would ask you to check your pay stub. Are you getting, say you're getting, for instance, $15 an hour? Are you getting that gross amount on your paycheck, or is that being reduced by something to account for taxes? If it's reduced by something to account for taxes and they don't have your SIN, that means they're keeping that money themselves, and that'll be up to you to figure out when you do your taxes. This is looking quite fishy, I have to say, Joby. And a few things I would tell you to do would be first to call the Employment Standards Department of the Ministry of Labor and report this. Secondly, you might want to get in touch with the CRA and explain the situation, right? Because you don't want to be left with a bill for thousands and thousands of dollars on unpaid taxes, right? So if they're paying you the gross amount, if, for instance, you work one day 5 hours at $15 an hour, and that works out to $65. For instance, if they're paying you the $65 and not deducting any taxes, that's one thing. But if they're paying you, 2/3 of $65, because the rest is theoretically going to taxes and EI and CPP, but they don't have your SIN, then they can't pay that to EI, CPP, and taxes, right? So they're pocketing that money, and you're going to be left with a bill, right? So definitely kind of look into that, I would say. Yeah, it doesn't look all that above board right now. All right, we have, really, this is the last question. We have it coming in from Adam, from Mustafa Adam. This one slid in right before the cutoff. I worked for my employer for nearly 3 years and was laid off without cause and offered 3 weeks severance. How difficult is it to get more, and does it tend to take a long period of time? So In my experience, a lot of our cases were able to resolve within the first few weeks after your termination. All right, and this seems like one of those cases. All right, so if you've been listening since the start of if you've just joined us, Mustafa, the first thing you need to know is how much severance you might be owed. All right, so the way you figure that out, visit pocketemploymentlawyer.ca. Pocketemploymentlawyer.ca is a website where we'll ask you 4 easy questions, no obligation. And from those 4 questions, we're able to advise you what we think are your severance entitlements. And likely it's a lot more than 3 weeks. All right. And then once you see how much is owed, then you can decide if you want to pick up the phone and call us to discuss improving that severance. 3 weeks sounds to me like it's the minimum you're owed under employment standards legislation, which means you will get that whether or not you decide to sign any of their documents, right? So what they've offered you, they cannot offer you less. They have to pay that to you. So essentially you have nothing to lose by speaking with us, because you may be entitled to a lot more, and your employer isn't going to revoke the 3 weeks or anything like that. That rarely happens in any case, but I know a lot of people are worried about that. But in this case, it can't happen. If they revoke that, they're in breach of the employment standards legislation. And most employers don't want to be in breach, because the Ministry of Labor can come down and cause problems and all of that, right? So take a look at pocketemploymentlawyer.ca. And if you think that what we're saying you are owed is worth your while, pick up the phone. A lot of these matters settle relatively quickly within a few weeks of you getting in touch with us. All right, so definitely pick up the phone, have a call with us, and we'll let you know what we think. All right, so I'm Lluc Cerda. I'm the managing partner of the Calgary office of Samfiru Tumarkin. I'm the Western Canada employment practice leader. And I was here today to answer as many of the questions that you have regarding employment law as I could. It was great. Thank you for sharing your great questions today. As always, we have a great audience. We have another show coming up on Wednesday with Lluc Samfiru himself to take on any questions that you were not able to get answered today. We want to make sure that any question you have about employment law, you have a place where you can get a quick answer from an experienced lawyer. So if you have anything that you want to discuss with us, join on Wednesday. We'll see you then. Thank you.